I'm Patty Wang, and I have the pleasure of introducing our next presenter, Elena Sallitto, on the subject Assessing Your Needs. Elena is a principal with Stavely and Sallitto Elder Law in Annapolis and earned her JD at Catholic University Columbus School of Law. She is also a certified elder law attorney through the National Elder Law Foundation and serves on many prestigious legal associations and councils. As if that were not enough, Elena is also a co-author of the Elder Care section of the Maryland State Bar Practice Manual and an adjunct professor at the law schools of the University of Baltimore and the University of Maryland, Baltimore. Elena's practice focuses exclusively on elder law, and she provides counsel to clients on long-term care planning, Medicaid planning, a variety of nursing home issues such as assisted living quality care, guardianship, powers of attorney, special needs planning, and much, much more. I think everyone will agree that we have the perfect presenter on this topic in Elena. Please join me in welcoming her. And as we do for each session, there will be time for questions for Elena at the conclusion of her presentation. You may enter your questions for her in the Q&A, and her slide deck will be available to our viewers. Thank you and welcome, Elena.
So thank you. I really appreciate the opportunity for being here and the topic of assessing your needs. This is the first time I've actually done a presentation on assessing your needs. And what I discovered as I was going through the materials and thinking about it was I was asking a lot of questions. And so this presentation is going to be a lot of asking questions. And as I pose the questions, I want you to, I'm hoping that it'll spark at least some questions, some answers in your own minds as you think about what your own circumstances might be, either now or at some point in the future. Because I think the utility of any estate planning really is dependent on the quality of the questions that you ask. And when you do this, it can be a little difficult and sometimes it can be a little painful. As you're asking these questions, you need to be really brutally honest. So you need to think about your family and the family dynamics and your own needs, not as you wish they would be, but as they really are. Because the more realistic you are in assessing your needs and in answering the questions that need to be asked, the better your estate plan is going to be, not just for yourself, but for anybody that you care about, that you're trying to provide for. So with that, I am going to go forward. And I always never know how I'm supposed to do this. Bear with me. I'm moving this. And here we go. I just need my little control. Here we go. Okay. Okay, I mean, first and foremost, it makes sense. What are your goals? What are your objectives as you're creating this estate plan? Do you want to provide for your family? Do you want to maximize tax liabilities? Do you want to ensure the specific assets go to certain individuals? Do you want to take care of charities, particular organizations that you've been involved in or that have provided a benefit to you or a loved one, or any other specific wish that you can have? And I think it's obvious your goals are going to change over time as your life circumstances change. Who you were at age 20 and what your needs were at that point were very different from who you might be at age 40, at age 60, at age 80. So as you go through life's challenges, your estate plan likewise needs to keep up with where you are and reflect what your current needs are. And just to note, I guess a little bit about an estate, you know, what the basics of an estate plan. I'm sure you've already covered this, but everybody has an estate. People tend to think of an estate as I don't have an estate that needs planning because I only have a little bank account. You have more than you realize that needs to be accommodated for. And as we go through this, I hope you'll see it too. So as we start to talk about our goals and objectives, or start to think about our goals and objectives, Start to ask yourself questions. Do you have minor children that you need to take care of? And this is a horrible confession on my part, but when my husband and I had minor children, our biggest stumbling block to creating a will was we couldn't figure out who the appropriate people or person should be to take care of our kids if something happened to us. So our estate plan ended up being no estate plan at all. And we were just going to kind of hope and pray that our kids made it to 18 relatively unscathed. Thank God they did. But, this is where, the cobbler's children have no shoes. Don't do what we did. It was really stupid. If you have young kids, ask the hard questions. No one is going to be as perfect as you are to take care of your kids. So give that up. But given that, so who's next best? Who's going to damage your kids the least? Maybe that's the way you approach it. But definitely provide for somebody to take care of your minor or disabled children. Doesn't have to be a family member. It could be a friend. Do you want to protect assets from a greedy in-law or in case of a troubled marriage? Not necessarily your own, but those of an adult child. You may have, you may be a little concerned about if something happens to you, your assets are going to go to a child who may be married or not married at the time. If they're married at the time, you may want whatever's left not to go to your son-in-law or daughter-in-law. Or your adult child may not be married, but may have a history of making very bad choices with respect to significant others. And that's not where you want to go either. So maybe you need to think about that. Do you want to recognize the sacrifice of a caregiving child or another individual? This generally is more for later years, but something you might want to think about. What about relatives, adult relatives who cannot take care for themselves? What about if you have a developmentally disabled child in the home who's now grown into adulthood and is probably going to be living with you for the rest of your life at least? How are you going to prepare for that person, provide for that person when you're no longer here? Avoid family disharmony. If you're going to provide for that person by giving them a good portion of the estate, how is that going to affect other members of the family? Again, you need to be honest. You can't just say, oh yeah, everybody understands, everybody knows that everybody's going to take care of Billy. When you're gone, the dynamics may very well change too. And what I find very often, which is surprising to me as an only child, but when a parent passes away, all the adult children suddenly turn age 5 again. And all of the dynamics and difficulties that they experienced growing up with each other suddenly comes out, and it's just amplified. So you need to be very honest and open about, is that a possibility that is going to need to be addressed? Just going to hover to the next slide. There we go. And remember, this is your plan. This is not anybody else's plan. It is confidential unless and until you share it. And there are certain circumstances or certain documents that you are going to need to share at some point, but it is confidential. Don't let anyone pressure you ever into creating estate documents that make you uncomfortable. It happens, especially again, as an elder law attorney, I tend to work a lot with, surprise, surprise, older people. And you would be amazed at the amount of phone calls that are initiated by adult children. That's, mom needs a power of attorney and I'm going to be it. And can you please, just I'll give you the information, draft the document, send it to us and we'll take care of the rest. It happens a surprising amount of time. Or we'll get a phone call saying, mom or dad really needs to change their will. I've been talking to them about it. They agree. We want to come see you. So your estate plan is confidential. It is no one's business but your own. When people are talking about possible inheritances or potential inheritances, they are that, only potential inheritance. There's no inheritance until the testator dies. That's the time that there may or may not be an inheritance. My personal philosophy, and generally adult children hate it when I say this because I will say it in front of them, is die broke. I'm a strong believer in it's your money, it's your wealth. You get to spend it however you want for your lifetime, and you make sure that you use that money for your own needs and your own comfort while you're alive. Uh, Die broke means that the last check on the bank account, it should be to the funeral director and should zero out the balance. That's just my personal philosophy. Beware of downloading forms from the internet. You may not get the plan you think you created. People always say, I have a simple will. It's easy. There's nothing there. And then what they don't realize is that, yeah, maybe the provisions of the will are basic. Everything goes to my spouse. If my spouse predeceases me, it goes to my children. But then they've done things on the side through either beneficiary designations or titling of assets that totally obliviates everything that they thought they did. The other thing that can happen very, very easily is you're putting forms in place where you don't really appreciate the significance of the words. And you think you may be having something done, but in reality, it's not going to have the impact that you think it does. So, I think it's worth sitting down with a lawyer, whether or not you actually have the lawyer prepare your documents, at least sit down, get a consult, figure out what kind of plan makes sense to you, and various provisions, and how complicated it really is not what you think it is. Next step, after you kind of gone through this little inventory about your family, now you have to do an inventory of what do you own? What do you owe? So you want a comprehensive inventory. What are the properties? Bank accounts, CDs, investments, stocks, bonds, life insurance policies, treasury bonds. People seems to forget, like savings bonds, all of that. The little tiny, tiny shares of stock that you may forget about, may not realize it's a big thing. But if you've passed and you've got this asset that doesn't have a beneficiary designation on it, and all it is like 15 shares of General Motors, and everything else has been taken care of in some other way through a trust or whatever, you may have to open a probate estate just for those 15 shares of General Motors. So when you do an inventory, make a comprehensive inventory. Same thing with your liabilities. Yeah, this is a valid, realistic picture. See what you got, and understand the inventory today that you're taking is going to help you craft the particular estate plan, but it's not necessarily going to be what your estate looks like when it's ready to administer, because a lot happens between now and death, or now and when you need to revisit your plan. How are the assets titled? This is huge. This is where people really get kind of a little off the beaten track. Joint tenants with rights of survivorship. Legally, those accounts, typically their bank accounts, automatically go to the surviving account holder. Where you've got a husband and wife or spouses, and it automatically goes to the surviving spouse, not a big deal. But if you've got a child, let's say an adult child on that account, and you put that adult child on the account because you want them to help you, and this just seems to be an easy way of having them have access to your money so they can write checks for you if you can't write them for yourself. At your death, that account automatically will go to the adult child, surviving child. That may not be exactly how you want your estate administered. You may want the money that's in there to go to all of the children. And while it's fine to say, oh yeah, I trust my child, they're going to do what's right by their siblings, why put that asset, why put that child in the position of having to defend themselves to the other children, going, yeah, I have it, but don't worry, I'm keeping books and records. I know how it's supposed to go. I haven't spent any money that I wasn't supposed to spend. I'm all right. Don't put your child in that defensive posture. T by E, tenants by the entirety, automatically go. That's a form of ownership that's reserved to spouses, and that property will automatically go to the surviving spouse. So, it may be exactly how you want it to go, It may not be. Beneficiary designations in any particular asset that you have. Typically, these are found in life insurance policies and in retirement accounts, qualified retirement accounts, IRAs, 401(b)(k)s, 403(b)s, etc. You may not want these to go directly to a beneficiary. You may want these to go to a trust for a beneficiary because there are certain issues with the particular beneficiary that need special attention. So just don't go say, with your IRA, let's say, yes, it all goes to my surviving spouse at at their death, the contingent beneficiaries are my kids. May or may not be what you want. Or yes, this is going to go to 50% is going to go to a child, 50% is going to go to a charity. You just triggered a whole bunch of different tax laws that you didn't realize that you triggered. So you've really got to take a comprehensive look at your beneficiary designations, make sure that they comport with what your actual goals are for how your estate needs to be administered or how you want it to be administered. Okay, moving on. Do you have something that needs special consideration? Business interests. Do you need a business succession plan? Are there family trusts, inheritances from others, investment properties, real property in other states, assets in foreign countries, vacation properties, pets, guns? All of these are going to require a little bit of thought. For example, we represent the personal representative for his sister's estate. She was a CPA. She was a sole practitioner. She died unexpectedly. She died in January. No business succession plan, nothing was in place. So this poor brother from out of town, with the help of a couple of her friends who are also accountants, are pouring through her files to figure out what needs to happen, who's out there. Mind you, we're in the middle of January. We're now at the start of tax season, and we've got all her clients starting to send all of this information into her so she can start preparing the taxes. Big problem. It required a team of people to be in her office for about a week, trying to sort through and contacting people and figuring out what to do and where things to go. So if you've got a business, if you are an owner and operator of a business, make sure there's a succession plan. That's a screaming need that you may not think about when you think about an estate plan. Family trusts. Is there something that needs to be addressed in the context of a family trust? I've got a trust right now that we've been dealing with property that's been in the family for generations. And now it's about to go to the next generation, and we are structuring many family trusts. So something like that. Inheritances that may be coming from others, how do you want that handled? If you're married and you're getting an inheritance, that is money that is yours alone under Maryland law. So in the event of a divorce, that money is not available as part of the divorce settlement, unless you commingle it, unless you gift it, unless somehow, some way you put your soon-to-be ex-spouse's name on it, then it might be up for grabs. So if there are going to be inheritances from others, you want to think about how you take care of that in the context of your overall plan. And just forewarning, you may think you've got the best marriage in the world, or you may think you're going to be married forever. Gray divorces are the largest growing segment of divorces in the country. A gray divorce is a divorce from somebody in their 60s and older. So you never know. Investment properties, that's big, and especially in terms of liability. People like to dabble in real estate investment. I know I've done that too. It's very cool. It's very fun. It can make you a lot of money, but it is also potentially a big liability. So how are you going to, how are you going to accommodate for that? Real property in other states. If you have real property, wherever you have real property and you pass away, you're going to need to open a probate estate in that particular jurisdiction unless you have a trust and put everything in a trust. So is there real property in other states? And if you are having to probate or open probate estates in multiple, in one or more states, it's a pain in the neck. It's very expensive. And that's something that you want to address as you're thinking about your estate plan. Do you have assets in foreign countries? Think about that. And I strongly urge you to contact an attorney in that foreign country. Vacation properties that you want to either keep in the family or give to certain people, pets. Yeah, you might want to accommodate your pet for your pets. There is such a thing as pet trusts. I put guns down here because there are special provisions for guns and there are gun trusts. I've never done one. I've never encountered one. Just make a note. If you have guns, you may need to accommodate for those. What about your health? People don't generally think about their health, I don't think, when they're thinking about their estate plan. But this is huge, and it really does need to be incorporated into how you structure things, especially if you've got, again, I'm an elder law attorney. We deal a lot with long-term care, mostly from chronic illness. Somebody has a stroke, somebody has heart disease, diabetes, all these things that are very, very common that cause us to need long-term care. This is not covered by insurance, and it's hugely expensive. So how are you going to take care of that? You can see from my slide, don't really need to go over it, but 70% of people who are 60 years old are going to need some form of long-term care. Men average of 2.2 years. Ladies, sorry, we are on 3.7 years. Are you going to look at long-term care insurance? Is that an option? Something to think about. Otherwise, are you going to be able to self-insure? Are you going to plan for self-insurance? Or are you going to look to Medicaid, which in Maryland only covers care at this point in a skilled nursing facility, a nursing home, which is not the most pleasant place to deal with. But you want to think about that. Be very careful about these 5-year Medicaid asset protection trusts. I know they're being touted quite loudly. The costs can easily outweigh any benefits, and they cannot own qualified retirement accounts. So they may not be right for you. And if you do decide to get a Medicaid asset protection trust, you better make damn sure that you are able to self-insure for at least that 5-year period. Because if you do create these trusts, you do end up needing long-term care within that 5 years. The state's going to say, you gave away that money within that 5-year look-back period. We're not going to meet your, we're not going to pay for your care. There's a set formula for how long they won't pay for your care, but it's lengthy. And if they're not going to pay for your care and you've put all your assets into this other trust, if you don't have enough money set aside to take care of you, you're up a creek, let's say. So be really, really wary of these. More on health, behavioral or mental health issues, developmental disabilities, other diagnoses, TBI, traumatic brain injury, dementia. Okay, if this pops up in the horizon for you or a loved one, this is huge in the context of estate planning, both for yourself and for your loved one. Do you need a supported decision-making agreement? This is something that's brand new in the state of Maryland. I think it's been in existence for, I think, a year, possibly 2, but it is something that's in lieu of a guardianship. So if somebody does need assistance, they're able to appoint helpers, supporters, and there's an agreement that must be recognized by certain providers, healthcare providers, financial institutions, and something that the courts are going to recognize. Special needs trusts. I happen to be at a special needs conference in Florida right now. That's where I'm speaking to you from. We have 2 days of just learning about these trusts and how to use them and what the pitfalls are and what the benefits are. These are trusts that allow someone who is disabled to hold a pot of money or to have the benefit of a pot of money and still be able to qualify for and maintain eligibility for government benefits such as Medicaid. So it covers healthcare, SSI, which is supplemental security income. So if they have no other source of money, SSI. possibly housing, possibly SNAP benefits. So these are hugely important trusts. And so if you've got someone with a developmental disability, let's say you've got a child that you want to take care of, special needs trust is immediately what you should be thinking about. For yourself as well, if you've got a disability, you're able to create a special needs trust. ABLE accounts are also been around, I think, about 5-6 years now. Wonderful tool for people with disabilities, gives people a lot of flexibility. There's a lot of planning that can be done between special needs trusts and ABLE accounts that give you a lot of latitude in how you can structure estate assets for the protection of someone with a disability, whether it's yourself or someone else. And so that's something that needs to be addressed when you're thinking about what your needs are. All right, let's choose our beneficiaries. Now that we've said, we've taken an honest look at who we are, what we have, what are our, what are our assets, what are our liabilities, who's in our family. Now let's say, all right, let's choose our beneficiaries. So who do you want to inherit your assets? Family members, friends, charities, organizations. Who do you not want to inherit your assets? In some instances, that's just as important as who you want to inherit your assets. You need to be crystal clear. If you're going to disinherit one of your children, and there are lots of good reasons to disinherit your children, either you've gifted them a whole lot of money during their lifetime, or during your lifetime, or they are a drug addict, or or they're a thief, for whatever reason. Lots of reasons to disinherit somebody. You've got to make it crystal clear in your estate documents. Is there a blended family? This gets very interesting. You've got a married couple, they each have children from previous marriages. They think they're taking care of everything. One will go to one attorney, another one will go to another attorney, each not realizing that this just came, I think an example would be the clearest way to get my point across. This came into my office. So blended family, children from separate marriages. The wife goes to one attorney and that attorney says, all right, we're going to do a will. Everything goes to your spouse at your death. Upon that, if your spouse predeceases, everything goes to your children. The husband did the same thing. So I said, well, like, wait a minute. So if you die first, your wife gets everything, and then at her death, her children get everything, and your children get nothing. He's like, no, that's not what we want. And so we sat down and she happened to be in the room, and she goes, well, that's not exactly what we intended. So you may need to coordinate at estate plans for a couple, especially when you've got blended families. Should there be a trust? Trusts are great for blended families. Let's say you have a bunch of money and you want to make sure your spouse is taken care of. This is probably a better way to go. So you would leave a trust for your surviving spouse, so they don't get it outright, they just get it in trust. And then at their death, it now goes to your kids. So that's kind of cool. Tax considerations for certain classes of beneficiaries. Basically, spouses and anybody in a lineal line, children, grandchildren, they're not subject to inheritance tax. Maryland has 3 types of taxes: estate tax, income tax if you need, and inheritance tax. The inheritance tax is levied on the person who is going to inherit. So if you have lateral bequests, siblings, nieces, nephews, cousins, they will be subject to an inheritance tax, most likely. So you want to think about that. Let's see. Who's going to be your executor? Who's going to be your personal representative? I know people people kind of think that this is a gift. This is like a badge of honor to be the personal representative. It's not. It's a pain in the neck, quite honestly. because this is what has to happen with the personal representative is they are going to go out, they're going to collect all your assets, they are going to open a bank account, they are going to monitor all the claims against your estate that come in, they are going to decide who gets paid, who doesn't get paid, and at the end of the day, they're going to write the checks to the ultimate beneficiaries. So you don't just appoint the oldest person because you think they would feel offended if they got left out. No, you're choosing somebody for a job, and the job has a specific skill set. Choose accordingly. They've got to be organized. They've got to be good with money. They've got to be able to keep books and records. They've got to be able to communicate with beneficiaries and heirs and with their siblings. So if the siblings are the beneficiaries and the heirs, it's helpful if they're on speaking terms. It doesn't always happen, but it really makes things go a lot smoother. This is what I was talking about earlier, designating a guardian for a minor child. Who should have this job? How are you going to provide for them financially? What is that going to look like? What is that trust going to look like? Who's going to manage it? Maybe the person who's going to be guardian over your children's well-being is not necessarily going to be the same person who's going to be the guardian or the trustee over their money. You have that latitude, got all kinds of flexibility. In addition to what happens to your stuff after you're gone, you also want to make sure that your needs are addressed while you're still alive. So healthcare directives, absolutely. Who's going to be your healthcare agent? And this is a person who should know you well. And this is a person who should be advocating for you to make sure your wishes are carried out and not push for what they think would be in your best interest. And not somebody who's going to be pushed around by the medical establishment. You need somebody with backbone. You need somebody that's going to say, no, my mother, my aunt, my friend would never have agreed to go to the hospital under these circumstances. Go away. So it's got to be somebody like that. Your job as the principal is to make sure your advocate knows what your preferences are. Your mission is to leave them guilt-free and not in a position of second-guessing themselves. Financial durable power of attorney, probably one of the most powerful documents you are ever going to sign in your entire life, because what you are doing is giving someone else the keys to the kingdom. We have a brand new statutory power of attorney document. It's been effective as of 20 days ago. Very powerful. Proceed with caution. You need one because if you don't have someone who is able to step into your shoes and manage your assets, if you cannot, then the only option is to go for guardianship, which is an abysmal process. So you really do need one. And this is not something you put off till you're 110 years old. Accidents happen every day. And I've seen people in their 30s, in their 40s, got in their 20s, have some event happen, and all of a sudden everything is shut down and nobody has access to anything, and they have to have a guardianship just because they need access to funds. So who's going to be your fiduciary for your money? Again, you're hiring somebody for a job. So it's your money. Who would you trust with your money? That's the question. So who's around you? Figure out who's around you. Obviously, they need to be honest. They need to be good with numbers, able to keep accurate books and records. They have to be good money managers. And they have to be not tempted by fate or other things. And, it can be, if you think about it, if you have a child, let's say you're going to appoint an adult child or a sibling, your adult brother, sister, somebody as your financial power of attorney. Let's say something happens to you and you're sitting on a whole bunch of money and your sibling or your child has needs that maybe they were unexpected. Maybe somebody loses a job. Maybe there's an illness. Maybe there's a drug addiction in the family. And they say, I'm an agent for this person. They've got $600,000. They don't need it, at least not now. I'm going to borrow $25,000 and I'm going to put back next month. Well, we all know how that goes, right? Next month comes, next month goes. Yeah, I'm going to do it. And, and what is it? The road to hell is paved with good intentions. So be really, really careful on who gets that. Tax liabilities. Sometimes these are an issue, sometimes these aren't. There are 3 types of taxes, like I said: estate taxes, inheritance taxes, and income taxes. Estate taxes, there is a $5 million threshold for Maryland, which means estates under $5 million will not be taxed. So you don't need to worry about that. And for the federal tax threshold, it's 12.92 million. If you are a married couple, you can have what's called portability, which means if you make an election with the feds at the appropriate time, there's a time frame, they will let you aggregate the unused portion of that $5 million exclusion from the deceased spouse and let you use it too, which means, in layman's terms, a married couple can give up to $10 million tax-free for Maryland purposes, and whatever 12.92 times 2 is federal. 25, 26. The federal number is due to be sunsetted, so that's going to be revisited. Inheritance taxes, I talked about. Income taxes, your PR is going to have to take care of your final income taxes, and sometimes there is income tax levied on the estate. Estate assets, if they appreciate in value between the time of your death and the time they are actually administered. Maybe you want to use gift strategies to get your, if you're in Maryland, you want to get your assets under $5 million. There's no gift tax in Maryland. I don't want to go too much into how the tax exclusion works for federal level, but suffice it to say that you can gift up to $12.92 million federally as well, without getting into any kind of gift tax. So, deathbed gifts, that happens. So if you're in Maryland, you have an estate at your death worth $5.2 million, give away the $200,000. Otherwise, there's going to be a tax levy of 16% on that $200,000. So this is usually not a problem for most people, so I don't want to spend too much time on it. Again, changes in circumstances are huge. So this is when you need to revisit what your estate plan is. I'm just writing myself a note I want to cover. 2 things that are not on the slides. So anytime you have a new marriage, a divorce, there's a move to another state, a disability, yours or someone else's, you got a business you created, yay, a dependent with special needs, changes in the tax laws, you need to review your estate plan to address these situations. Apologize for the typo there. Couple things. I know people generally will have a question of, do I need a trust? Do I need a will? That will get answered as you go through everything that we talked about. Once you do this inventory of who you are personally, and what you have and where is it located, that's going to tell you whether or not you need a trust. Sometimes you do, sometimes you don't. My personal preference is keep everything as simple as possible. Probate in Maryland is not a horrible thing. I don't know if it's because my office does it all the time, or it really is not an awful thing. I mean, some states, it's an abysmal process. Maryland, not so bad. You file the will, the petition, you get a tax number, you open the estate bank account, you sell what needs to be sold, you pay off everybody that needs to be paid off, and then you disperse the assets. Literally, that's what it is. So, trusts are much more expensive and cumbersome to set up in the beginning. You have to retitle everything into the name of the trust. The trust is only as effective as the assets that are contained in it. And again, it's much more expensive. Administration is very easy at the back end. You don't need to go to court. There's no court oversight. So, it's kind of up to you. It's a very personal decision. The last thing I want to talk about is, who do you tell about what? Remember, I said this is your plan and it's very confidential. And it is. But what is leading me to tell you this now is I am in a guardianship case, um, and it never should have happened. And the reason it's a guardianship case is because the mom, the principal, who is now incapacitated, she's not dead, she's incapacitated. And everybody's scrambling with how do we take care of her? So the first thing is she doesn't, there's no healthcare advance directive. So the doctors, even though they're not supposed to not talk to the son, are not talking to the son, saying, no, 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 can't talk to you. There's no advance directive. You need a guardianship. She's got assets that need to be managed. And, so how are you going to get to the banks? The banks, if you need to do something with real estate, anything that you need to do for her can't be done. She also was the owner and operator of this huge business in DC. And it makes, I think, like millions of dollars. And nobody can find, it was her alter ego. What do we do? So the guardianship case got filed. There's a temporary guardian that created a whole nother mess. And then the children who wanted to be guardians and are not guardians anymore suddenly discovered, wait a minute, we found a power of attorney. We never knew mom did this. There are other estate documents. We never knew mom did this. With respect to the business, they're going through things. And it's like, well, wait a minute, there's an estate, there's a succession plan. We never knew mom did this. Mom was very private. Now we are stuck in the very hapless decision or a situation of having to go to the court and saying, oops, we didn't need a guardian. And the court is going to go, well, wait a minute. What is all this after acquired stuff? Because in guardianship, the court is the actual guardian, and the court is very suspicious of family members, not all that wrongly, because there are a lot of not trustworthy family members that go before the court. So we now have to prove to the court that we never needed a guardianship in the first place, and would she please dismiss the guardianship? And this particular judge is not going to be in a hurry to do that. So who do you tell about your estate plan? You don't tell everybody everything, but I think you do tell the people that need to know in case something happens to you. So I think that needs to be a part of assessing your needs. Who needs to know? And what do they need to know? And where are you going to keep all your lovely estate documents so people can find it easily? Not just your financial power of attorney, not just your advance directive. Nobody gets mail anymore. Your passcodes. How are they going to get into the bank? How are they going to get into your financial records? How are they going to see what's in your bank statements? How are they going to know what you have, what accounts you have, where you have them? So you need to put that in a place where people who need to see it can see it. With that, I'm going to turn it over, I guess, to any questions. So thank you. I think I've covered what I wanted to cover.
Thank you, Elena. We have lots of questions from our viewers, and we'll start with the first one. It's, can you protect your married children from an unhealthy relationship with a son or daughter-in-law? Is there such a practice of having a trust and leaving your money and property to a son or daughter trust rather than directly to the son or daughter?
Yes, you can. And that's the way to do it, is to put the money in a trust, and then you're going to have to put guardrails on how that money gets accessed. The problem is, are you going to insult your son or your child by not giving them unfettered access to the trust? The only way to totally protect the money in the trust for that child is to remove it from their immediate control. So you would really need somebody else to manage it. And that could be an issue. I mean, that could just make them really angry with you, but you'll be dead and they will just shake their fist at you from heaven or from earth going, Mom, Dad, I can't believe you did this to me. But that's the only way to do it. Otherwise, you just have to leave it to them and talk to them. and say, look, honey, you never know what's going to happen. Please don't commingle this money. Keep it in a separate account and put your children on as beneficiaries, because you can do that.
Okay, great. The next question is, are there online web forms for wills and trusts that you would recommend for organizing and getting started before meeting with counsel? This person does not want to enter their personal information on a website.
Yeah, no. Generally, when you contact a lawyer about an estate plan, they're going to send you a huge questionnaire that is going to make you put all this together and make you pull your thoughts together. Otherwise, just download estate planning questionnaires. Don't enter any information online. Just download it, print it out, and prepare it for yourself.
Okay. And then the next question is, can you leave assets for children that specifies the assets do not go to bill collectors?
Yes, you can. That's called a spendthrift trust provision. And what it does is essentially prohibit anybody from saying, hey, I'm a trust fund baby. And I'm going to get this Lamborghini, and Lamborghini people, you can use my trust money that I have. Yeah, there's something that you put into the trust document, and that takes care of that.
Okay, the next question is, I have a disability. What is a special needs trust for myself?
It's called a D4A trust. And it's depending on your age, you can set up what's called a D4A trust or a D4C trust. And these are the D4A, the D4C, those are references to code provisions in the Social Security Act. You would need to get hold of a lawyer who does this stuff. Not all lawyers are familiar with special needs trusts, but it's a way for you to hold your own money. You give it to a trustee in this D4A or D4C trust. They have exclusive control over it. You are then eligible for government benefits. Understand, you don't have independent access to that money anymore.
Okay, and somewhat related to the previous question, this viewer asked if you could please re-clarify what is an ABLE.
What is an ABLE? Oh, the ABLE account?
Yes.
Okay, ABLE account. ABLE accounts are a corollary to the 529 educational accounts. So they are a creature of the Internal Revenue Service. They are very cool accounts, very easy to set up. They are specifically for disabled people. Right now, the disability must have occurred before age 26. In a couple of years, I think in 2026, the age is going to go up to 46. But right now, you have to be, the disability must have occurred before age 26. It's a special bank account, and you can open it with money from a special needs trust. Other people can put money into it. It's a maximum of $17,000 a year that goes into it, and it gives you freedom. It lets you spend money on things that you couldn't otherwise spend money freely on if they were stuck in one of these special needs trusts. If you look at marylandable.org, just Google marylandable.org, you will find all the information you need. ABLE stands for Achieving a Better Life Experience, ABLE.
Okay, our next question. Can an executor hire an attorney to help administer the estate? And can the attorney's fees be charged to the estate?
Yes and yes. And that always happens. Unless it's a small estate, then there are restrictions on whether the attorney's fees and PR commissions cannot come out of the estate. But short answer is yes.
Right. And does the executor receive a fee for being the executor?
They can. If you have a regular estate, which depends on how big it is, the PR absolutely can charge a commission, and there's a statutory formula for doing that, but it's taxable as income. So if your PR is also an heir, inheritances are not taxable. So very often, or mostly, the PR will forego the payment and just take the money out as non-taxable inheritance.
Okay. And the next question kind of goes back to an earlier subject. It's a little bit longer, but if an executor might be biased or hateful against an heir, and the heir has no good reason to trust the executor, so I guess it goes both ways, how can the heir challenge in court the fitness of the executor for that role? Why don't you answer that first, and then I'll finish the rest of the question.
By filing a petition with the court. It's with the Orphans Court. There are forms online. If you go to the Register of Wills website, you can see all the forms. And just, you're going to go to the court and say, hey, this isn't going to work, and these are the reasons why. You have to have a substantial reason. You know, you can't just say, I don't like him, don't trust him. You need to demonstrate why this person is not fit to be the personal representative.
Okay, I think you may have addressed this part of the question, but would the heir have any recourse in court to have executors removed from those positions? And the condition, for example, is that there's actually proof that the executor has either stolen from the deceased or would like to use that position to conceal their dishonesty.
Oh gosh, yes. The Orphans Court doesn't like people to do that. And if you provide any evidence, credible evidence of that, that person is immediately going to be removed, and may also be liable to the estate for whatever it is that they took, if they took anything.
Okay, well, we have several more. If a beneficiary has been identified on a life insurance policy, for example, and later you name someone else as a beneficiary in their will, which one would take precedence?
This is where you've got to watch out of beneficiary designations, how accounts are titled, and your will. If the asset knows where it's supposed to go at your death because there's a name attached to it, it does not see the will. So a life insurance policy that is payable to John Brown is automatically go to John Brown, regardless of what happens in the will. It will never see the will.
Okay. What about the situation where there may be a will and you know the person would like to change or revise it, but the family member that she's living with will not allow her to go to the necessary location to make that change? And in parens, it says she's confined to a wheelchair and cannot leave on her own.
This is complicated. If someone is aware of this situation, because we're talking now abuse and potentially financial exploitation, you can call Adult Protective Services, have them come out, and they can get involved when they've got someone who's not able to take care of themselves, and you've got somebody confined to a wheelchair. That pretty much will meet that definition. The problem is going to come in where you've got the caregiver who meets people at the door and says, we're fine, go away. And they open the door a crack to let the APS officers see the person in the wheelchair, and the person in the wheelchair, because they are intimidated, said, yeah, hey, I'm all right. That gets rough. You can also petition the court for guardianship, and that would likely be the way to go.
Okay. Which documents can and cannot, or should not, be filed with and held by the County Register of Wills? And are there other documents that you may want to mention?
The only document that the Register of Wills is going to take is the original will. So if you've got a will that you drafted, you don't want to keep it home, you can always deposit it with the Register of Wills. I think it costs $5, and they will keep it forever until you pass away or until you want it back. So that's just real good safekeeping for the will. Other documents, if you've got a domestic partnership, this just changed. This is brand new. A domestic partnership is two people unmarried, but they basically share a household with the intention of being like a family unit. There are special tax preferences for that, and there needs to be an affidavit of domestic heirship or domestic partnership, sorry. That does need to get registered, and I believe that gets registered, I want to say, with the land records. I'm not 100% sure because it's brand new, but that would need to be registered. So go talk to your lawyer, someone who knows the answer better than I do, or ask me and I'll go look it up. I just don't know the answer off the top of my head.
Okay. The next question, can I simply designate a bank account inheritor on the account and skip considering it in the will?
Yes. You can use beneficiary designations on any bank account. They're called pay on death or transfer on death or beneficiary accounts. Yeah, on just about anything you own.
Great. And then you may have answered this earlier, Elena, but are there trustworthy online sites to access estate planning forms and documents?
If you're, go to the Attorney General's website, Maryland Attorney General, and they have the advanced directives. They generally have the financial power of attorney document. I would really strongly urge anybody who's looking to do a financial power of attorney to meet with a lawyer to do it, because there are little nuances that are in it that you may or may not understand. It's a technical thing, and it really helps to have somebody go through it with you. And as far as wills, no, I really don't know. I'm not a fan of LegalZoom. If you're not a lawyer and you don't know what you're looking for, people get in trouble when they don't know what they don't know. And I think that's just my warning for everybody.
Yeah, that really is a punctuation mark to, I think, the first session. So our last question is, can you say more about tax considerations when giving gifts to charities?
It's deductible. It's deductible. It's a good way of getting your estate below the 5 million mark if you want to. It's deductible off of your income tax if you exceed whatever the standard deduction rate is. That's the benefit and the beauty of it. If you put a charity as a beneficiary on a retirement account, you have possibly triggered tax issues for any other beneficiary on that same account. So you would need to watch out for that.
All right, well, that covers all of the questions that we got from our viewers. Thank you so much for your presentation, Elena, on elder law, and for holding the record of answering every single question. Thank you.
Thank you, everybody.